Court. My name is Joanna Boyer.
And my name is Makaylia Askew.
And we represent the petitioner, Tyson Timms.
We are arguing that the protections of the 8th Amendment's excessive fines clause prevents the state of Indiana from seizing Mr. Timms' vehicle because 1, the excessive fines clause of the 8th Amendment should be incorporated through the privileges and immunities clause of the 14th Amendment, and 2, the due process clause also offers protections to prevent Indiana from placing unreasonable fines on Mr. Timms.
Would the court benefit from a brief recitation of the facts?
Yes, please.
In the beginning of 2013, Mr. Tyson Timms became addicted to a prescribed pain medication until his prescription ran out and he turned to heroin. In May, a confidential informant connected Timms to heroin dealers and told police officers that he would be able to buy heroin from Timms, which led the officers to set up 2 controlled drug buys. At the first buy, the police officers acquired 2 grams of heroin from Timms for $225. At the second, they acquired another 2 grams for $160.
In June 2013, the state charged Timms with 2 counts of dealing a controlled substance and 1 count of conspiracy to commit theft. During the criminal court proceedings, a law firm acting on behalf of the state began filing a case to forfeit Mr. Timms' Range Rover. Timms then pled guilty to 1 of the felony dealing charges with a conspiracy to commit theft charge in exchange for the dismissal of the remaining charge. After accepting the plea, the trial court sentenced Timms to 6 years and had him pay fees and costs that totaled to approximately $1,200.
In response to the motion to take Mr. Timms' vehicle, the trial court concluded that the forfeiture would be an excessive fine under the 8th Amendment, stating that it would be grossly disproportionate to the seriousness of Timms' offense. The court noted that the maximum statutory fine for Timms' felony dealing charge was $10,000, and the vehicle was worth roughly 4 times that amount when Timms purchased it. The trial court ordered the state to release the vehicle immediately, and the Court of Appeals affirmed.
When looking at the Privileges and Immunities Clause, the Indiana Constitution defines privilege as a right or immunity not enjoyed by others, and defines immunity as a right to obligation or particular privilege.
Austin v. United States has held that, like the other 8th Amendment protections, which have long been understood to apply to the states, the excessive fines clause prevents governments from abusing their power to punish. And although this court's incorporation cases have typically been built upon the due process framework, the Privileges and Immunities Clause provides an alternative path for holding that the excessive fines clause applies to the state.
And like other rights secured in the first 8 amendments, the right to be free from excessive fines is one of the privileges and immunities of the citizens of the United States, which no state may infringe. And at the time of the ratification, the clause was publicly understood to enforce those fundamental rights enumerated in the Constitution against the states. The court in McDonald v. City of Chicago held that the right to be free from excessive fines fits comfortably within the original public meaning of the Privileges and Immunities Clause.
But even if I agree with you about that, this case deals with a civil in rem forfeiture. Isn't that different than a fine? A fine is meant to punish, and this in rem forfeiture was meant to remove the instrumentality of a crime.
No, Your Honor. As held in Austin v. United States, the excessive fines clause applies to civil in rem forfeitures when they serve in part to punish. The forfeiture in today's case clearly exists in part to punish. The trial court recognized that whatever additional purpose of the forfeiture served, it is also served to alleviate the substantial negative impact on society of trafficking in illegal drugs.
In the case before the court today, a private law firm filed a case against Mr. Timms to forfeit his vehicle on behalf of the state of Indiana. The forfeiture that they asked for Mr. Timms' vehicle is 4 times the maximum fine that the state was going to charge Timms. To have this excessive fine be protected under the Privileges and Immunities Clause would not only protect Mr. Timms' 8th Amendment right, but it would set precedent that would prevent states from placing similar fines on citizens for their own personal revenue.
And even before the ratification of the 8th Amendment and the Privileges and Immunities Clause, states were abusing their power to fine their citizens. Harlan v. Michigan found that the sovereign power to fine remains prone to abuse, and unlike other forms of punishments, fines are a source of revenue because the states stand to benefit from them. There is a profound risk that governments, federal and state alike, will exercise their policing powers not to do justice, but to raise revenue.
In McDonald versus City of Chicago, the court not only evaluated the right's history, but also whether the right had remained fundamental over time. In their analysis, they held that the right to be free from excessive fines continues to be fundamental today. Like imprisonment, economic sanctions can effectively control a person's life, strip them of their property, and deprive them of their freedom. Browning versus Kelko found that the state of Indiana illustrates that these sanctions remain prone to abuse, with the government's impulse to raise royal revenue competing with its duty to act fairly and justly. Indiana has even gone so far as to use such sanctions to deprive people of their homes.
The law enforcement officers in Indiana did not even hide the fact that they view economic sanctions as an important source of revenue. And since 2016, court enforcement officers in Charleston, Indiana, have flooded a low-income neighborhood with millions of dollars in property citations. Using fines, the mayor and the city sought to help a developer buy property in the neighborhood. A court later found that the mayor anticipated that the plan to enforce the property maintenance code would impose such a steep fine on the owners of properties that they would be willing to sell to a developer for demolition.
The state of Indiana doesn't stop there. They, unlike most states, allow prosecutors to outsource civil forfeiture cases to private lawyers on a contingency fee basis. This case, for example, was prosecuted by a private law firm while the case was still pending. Indiana has even codified fixed percentages of civil forfeiture revenue that those law firms can collect. Your Honor, allowing the state to incorporate excessive fines under due process clause would allow them to impose any fines that they wish, no matter how excessive or out of line with the fundamental principles of justice and fair play, by merely stating that they gave due process.
And even if the court to look past the compelling reasons to incorporate the excessive fines under the Privileges and Immunities Clause, the Due Process Clause also offers protections that would restrict the state of Indiana from using civil forfeitures to place an unreasonable fine on Mr. Timms. As held in McDonald v. City of Chicago, a citizen is guaranteed protection of due process when a right is fundamental to our schemes of ordered liberty or deeply rooted in this nation's history and tradition.
The right to be free from excessive fines is fundamental to the nation's scheme of liberty. In addition to being fundamental under the Privileges and Immunities Clause, this right has also been considered fundamental when looking through the Due Process Clause. As recognized by Justice Bradley in the slaughterhouse cases, the right to property and its protection is one of the great threefold divisions of rights of free men, fundamental rights which can only be taken away by due process of law.
The right to be protected against unreasonable fines is also deeply rooted in our nation's history. The founders intended the Eighth Amendment's primary focus to be the potential for governmental abuse of its policing powers, as held in Browning v. Makaylia. Thus, the right to hold and enjoy property without fear of states' abusive policing power is not only fundamental in American liberty, it is also historically one of the main concerns of the founders when they passed the Eighth Amendment.
The courts have also recognized this deeply rooted tradition of protection by continuously holding that excessive fines and the excessive fines clause is applicable to the states in cases like United States versus Austin, Hall versus Florida, and Hudson versus United States, even when the case deals with civil forfeitures.
Considering the deeply rooted tradition of requiring moderate and proportionate punishments have been consistently recognized by the court, and it is clear that Mr. Timms is guaranteed due process of law. However, Indiana has used civil court systems to circumvent the law and apply a less rigorous standard when determining whether property should be taken.
But isn't the outsourcing to a law firm to go into civil court simply an issue of expediency? I mean, if we required all civil in rem forfeitures to happen in criminal court, that would flood our criminal courts and slow down the process.
Your Honor, while transferring the case to a civil court does allow for expediency, the line between expediency and violating a citizen's due process rights must be drawn. And Your Honor, the state of Indiana has used the civil court system to circumvent the law and cross that line by violating Mr. Tim's due process rights in two crucial ways. First, by denying him a proper burden of proof, and second, by denying him access to a jury. First, when dealing with an issue brought before a criminal court, the beyond a reasonable doubt standard is a requirement of due process, as held by Victor v. Nebraska. The same standard must also apply to civil court cases brought forth by the agents of the state or on behalf of the state, as the private law firm in the case at bar did, as recognized by Chicago-Burlington v. City of Chicago. This means that a private law firm acting on behalf of the state in a civil trial should be held to the same burden of proof as the state in a criminal trial.
Allowing states to use civil cases to lower their burden of proof gives the protection against excessive fines no meaning because the state has given one of its agents the power to evade it, as held in Navy, Delaware. This danger is even more evident when the law firm acting on behalf of the state begins a civil case to forfeit a citizen's property before the citizen has been determined guilty or innocent for the criminal charges, which is exactly what happened in the case before the court today.
Second, Your Honor, Indiana has denied Mr. Tim's adequate due process because in the state of Indiana, forfeiture jury trials are not available. The right to a jury trial in federal civil in rem forfeiture was given in the case United States v. 1. And, Your Honor, as held in Malloy v. Hogan, rights incorporated under the Bill of Rights and incorporated to the states are enforced against the states under the 14th Amendment according to the same standards that protect those rights against federal encroachment. So a jury should be available to property owners being forced to give up or forfeit their property, regardless if the case stems from a federal or state action.
Even bypassing the different standards and the lack of rights typically offered in civil forfeitures, Mr. Tims was still denied due process of law because the state of Indiana subjected him to an excessive fine, one that is clearly disproportionate to his crime. In states like Indiana, modern civil forfeiture cases have led to a shocking and well-chronicled abuse, as recognized in Leonard v. Texas. In 2012, the Institute of Justice reported that agencies took in more than $254 million in forfeiture under state laws alone, placing a forfeiture that was 4 times larger than the maximum fine, in addition to the court's fines already levied on Mr. Tims, is clearly an example of such an abuse of the government's power and should not be permitted.
As held in Hudson v. State, a forfeiture that is grossly disproportionate to the gravity of the petitioner's offense is unconstitutional under the 8th Amendment's excessive fines clause, and a forfeiture which is 4 times larger than what the court has already determined proportionate to the gravity of the petitioner's offense in criminal courts is clearly disproportionate. The importance placed on protections from excessive fines can be found throughout history and legal precedent, and it makes it clear that a line must be drawn between permissible punitive punishments and excessive civil forfeitures to prevent states from using the civil forfeiture system to bypass criminal due process safeguards such as maximum fines, a higher burden of proof, and a jury.
The 8th Amendment excessive fines clause should be incorporated through the privileges and immunities clause of the 8th Amendment and the 14th Amendment because the privileges and immunities clause creates better protection for citizens from states that abuse their power to punish. And the 8th Amendment precedent has been consistently recognized the right to be free from excessive fines as one of the privileges and immunities of the citizens of the United States.
Even viewing excessive fines under the due process clause, Mr. Tims should have still been given due process because the right to be free and protected from excessive fines is fundamental to our system of liberty and deeply rooted in our nation's history. However, the state of Indiana has used the civil court system to deny Mr. Tims due process, but by denying him a more protective standard, denying him a jury, and setting a fine that is 4 times the maximum punishment for Mr. Tims' crime. It is for these reasons we pray the court protect citizens' 8th Amendment rights, and to do so by ruling in favor of the petitioner, Tyson Tims, in today's case.